A Bengaluru electronic company launched a product and immediately received a patent violation notice. But when we checked the competitor patent, we found something shocking. The invention already existed globally. The patent should never have been granted. Hi, I am Ayushi from Diligence Certification. Today I will explain patent revocation in India. What it is, who can file it, and how it protects genuine innovation. What is patent revocation and why it is matter? Patent revocation means cancelling a patent that was wrongly granted. If a patent lacks novelty, is obvious, misleading, or harm a public interest, the law allows it to be revoked. In India, patent revocation is governed by Patent Act 1970. Any affected businesses, researcher, or even the government can challenge such patents. Grounds and special provision for revocation. A patent can be revoked if it is not new, has no inventive step, cannot be used in industry, or was obtained through false information. Indian law also allows revocation in special cases if the invention affects the public interest, if it is related to atomic energy and national security, if the patent is not being worked in India even after a compulsory license. Procedure and who can file. A revocation petition is filed before the High Court, supported by prior art and technical evidence. The patent holder gets a chance to defend, and after hearings, the court may cancel, amend, or uphold the patent. Any interested party, a defendant in violation cases, or the government can file for revocation. At Diligence Certification, we help businesses challenge invalid patent and defend rightful innovation. Don't forget to like, share, and subscribe for more insightful videos. Thanks for watching.